Appeals for the City of Westminster now in session. Approval of minutes, I guess, is left over from the other meeting, which never really got started. So has everybody had a chance to look at what we had from before on the board?
Yes.
Do I have a motion?
I move to approve the minutes of the last
Yes.
meeting.
Have a second?
Second that.
All in favor? Aye.
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 So approved. We'll proceed to case number 20-02, the rehearing. I'll read from the agenda, but then I have another little separate introduction to weave in here to kind of help recap things as well. Hearing on a motion of the Board of Zoning Appeals resolution and decision dated June 23rd, 2020, filed by applicants Mid-Atlantic Lubes LLC, contract purchaser, and property owner Abec Property LLC, seeking modification of the findings and reopening the record in the case to allow rehearing on the subject of the applicability of zoning ordinance 164-140 to the applicant's request for a special exception to operate a service station at 335 Gorsuch Road, Westminster, Maryland, in the B business zone. The board shall consider further testimony from all interested parties limited to the subjects raised in the applicant's motion for modification and the board's order to suspend 20-02 of July 16, 2020, including any procedural or substantive objections to applicant's motion. So we are here on applicant's motion for modification of the findings and order of the board dated June 23rd, 2020, in this case 20-02. As chair, I treated that as a timely motion for modification filed pursuant to Board Rule of Procedure 18 as it was filed on June 26th, 2020. The applicant's motion was by email from Mr. McGuire, counsel for the applicant, to counsel to the board dated June 26, 2020, which was previously been sent to all parties. Without objection, I will mark, or Eric will mark as Exhibit 16 and enter into the record. Is there any objection?
No objection.
No objection.
So moved. So before we begin the presentations and analysis of that motion, are there any procedural motions or questions to be offered at this time? Okay, hearing none. I'd like to request that Mr. Blitz, our counsel who prepared the memorandum, will mark as Exhibit 17.
The memorandum that I prepared is
Yes.
17. Okay, great.
And all parties have seen that memorandum? Is that correct?
Yes, the applicant has seen it, but does not necessarily think it ought to be part of the record in the case.
Okay. Is any further comment or action to be taken on that?
Just an explanation why you don't want it part of the record.
Well, it introduces a lot of extraneous material. It attaches about a dozen prior board decisions. And although I understand why it's relevant to internally to the board's analysis, I don't know. I think it clutters the record unnecessarily.
Makes sense to me.
So these documents will be on record from the previous conversations and not necessarily for this one.
Previous hearings, yeah.
Yeah. I'm okay with that.
So is that a formal objection not to admit?
Yes.
I guess maybe a question for Eric. Can we, if we exclude the whole set of documents, does that give us an incomplete record? I understand it. Ideally, it would be, it would be better to exclude the extraneous materials in terms of what the applicant is suggesting, but do we, I guess, cause problems for the record itself?
You don't cause problems for the record. It's obviously the board members have seen it. Should there be an appeal, it would become part of the record that would get transmitted because you have seen it. So in that sense, excluding it from the quote record upon which you derive findings doesn't make a whole lot of difference. But I think no. The answer to your question, Mr. Burrant, is that no, it doesn't create a problem for you. It's just it was the chair's request to provide a history of the board's actions on 164, 140, as well as the citations that were referenced in the code. So that is, it was treated as not being a giving legal advice to the board so that it could be public, so that it could be part of the record. Doesn't mean
But
it has
since
to
they're
be.
already public documents, I don't see that we have a problem with them. I mean, excluding it, we could make a reference to it perhaps.
Well, if you're going to have discussions, deliberations about the contents of that document, it would be preferable for it to be included in the record.
Yeah, I agree. If we get into a discussion, I would say just make a motion to exclude it as requested, with the exception that if we need any of the documents within that particular group of documents, that it be allowed into as a part of the record if Mr. McGuire agrees.
So the chair could, in effect, the chair can rule on the admissibility of the document, and then Ed, your options could be, there's a number of them, but based upon what Larry just said, you could suspend action on moving it into the record until later in case it's necessary. Or you could exclude it from the record now, but stipulate that that issue can be revisited later in the case. I generally prefer the first because the second creates expectations of parties that may not play out as the hearing goes on. And so they don't know, to be fair to them, whether it's going to become part of the record or not. So, or you could just rule it either being included in the record or excluded, as as the applicant's counsel has suggested.
Part of the intent here was to inform all the parties concerning the applicability of 164-140. And where in fact, it has been considered in like cases in the past, and obviously would raise the question as we proceed in terms of the applicant's challenge and the staff's withdrawal of consideration for 164-140, which I guess we'll intend to further investigate here. So.
Well, I'll go ahead and I don't know whether we do it by motion or whatever, but to, I guess, defer applicant's request for the entering of the staff report, I guess this staff report for the modification of the rehearing, and leave it till later in the hearing to see whether we want to include it or exclude it.
I would just ask either that you consider that was not the applicant's request. It was right. The chair was moving it into the record.
No, but the applicant has asked that I'm talking about his request, the applicant's request.
So
I don't care how you phrase it, but you know what I'm saying.
Well, I just want to make sure the record is clear. You're making the motion to the chair that he should rule that the question of admission of this document should be deferred. Is that what you're asking?
Yes. If that makes sense to anybody else.
Which would be over the objection of Mr. McGuire as applicant's counsel.
Well, I have no objection to deferring the ruling to a later point. If the board feels that it becomes relevant during your discussions, then I really don't have an objection to deferring that decision to a later point.
Okay, so with Larry's motion then, or recommendation, then I would accept that recommendation that we defer it until later if it comes up in the discussion again.
Before you proceed, can I ask, are there any members of the public or other parties in attendance that also need to be heard on this question?
I had asked Andrew earlier, and there was no others at the time that we actually turned on and got started.
Okay, I'm just making sure nobody else is here.
Andrew or Mark or Andrea, are you there to respond?
Yes, Mr. Chair, it does not look like anyone else would be here for that case. Ms. Dubé, who is also on video, is here for the second case.
Right. Okay.
Okay,
Mr. Chairman, I would also add that I got an email from Brooks Leahy, who represents one of the adjoiners, and he did in fact participate in support of the application at the original hearing. Sent me an email saying they continue to support it. He's aware of the hearing, but they decided not to expend their resources to participate actively.
Okay.
At some later point, Mr. McGuire, are you going to offer that into the record?
Just going to ask that.
Sorry.
No, I think my verbal representation is satisfactory.
All right, so accepted. So moving forward, I just want to go through these as kind of a refresher for everyone. Motion for modification raised 4 issues, from which the first 3 appear to be more clerical corrections. We don't need to spend much time as those. They were previously accepted as clerical corrections. So I'll dispense with going through those if everybody's okay with that. Hearing none, the 4th modification request is not typographical, but seeks the removal of findings 40 and 41, which describe the potential applicability of section 164-40, 164-140 to present application for a special exception. So this is really why we are here with this rehearing. I think it's important to first describe what those findings were. So I'd ask Mr. Blitz to read into the record the board's findings for 40 and 41.
Okay, 40 reads, section 160-140 imposes a distance requirement that reads, quote, any uses of buildings subject to compliance with this section shall be located at least 100 feet from any other lot in a residential zone or in any other zone which contains a dwelling, school, place of worship, or institution for human care, end quote. Finding 41 reads, planning staff, see Exhibit 2, raised the question of whether the applicant can meet the requirements of section 164-140, period. The applicant proposes to move the building eastward so the distance between the building and the Carroll County R7500 residential zone to the west of the property will be increased when compared to the existing veterinary use. However, it will be less than 100 feet from the Carroll County zoning. To the southwest of the property, the town's R7500 residential zone starts, but it appears that a building is over 100 feet from that zone. The proposed automobile service station use will be 68 feet, parentheses, less than the required 100 feet, from the Tevis property to the south, which, while in the B business district contains a dwelling. Therefore, the proposed use may not meet the requirements of 164-140 of the zoning ordinance, and therefore may require either a variance or, if applicable, an administrative adjustment. By this order, the board does not rule on the availability of either option for the applicant, as that issue was not sufficiently noticed or presented to the board for resolution.
So the staff, I'm sorry, any comments to that? The staff have submitted an amendment to their staff report, confirmed that all parties have received a copy of that report.
Yes, the applicant has received a copy.
So that we want to admit into the record as Exhibit 18.
No, that would be 17 because you didn't admit.
Oh, that's right. I'm sorry, 17. And unlike a normal case where we would hear from the staff first, this is a motion from the applicant. So we'll first hear a presentation from Mr. McGuire on his motion.
Thank you, Mr. Chairman. Didn't realize we were going to do that. I was going to rely on the wonderful staff report, but I guess I'll make the pitch. Section 164-140 is the sole issue, as has been stated, and it would impose a 100-foot setback on this project. I want to say right out of the blocks, this project could not meet the 100-foot setback. I mean, should be apparent from the site plan that's part of the record that the depth of the lot is roughly in the 130 to 150 foot depth. So there's no way that we could move the building 100 feet from the building on the Tevis property. Also, I want to go back and summarize a little bit the relevant history and the context, partly because Mr. Blitz made it clear in some communications with us that not all of the email communications we had with him by way of argument were passed through to the board. So to me, it's not crystal clear what the board has considered and what it has not considered. So this goes back to the original hearing on May 5th, 2020, and I will read the discussion where Andrea Gerhardt, staff member, withdrew the section of the original staff report that would have imposed the setback in section 169-140. Andrea said, and this is at minute 14:05, and I'm reading to minute 15.25, so a little over a minute of discussion. Andrea, Ms. Gerhardt, I wanted to take note that the additional zoning ordinance regulations found on page 12 of the staff report that discussed how there is a 100-foot requirement that may need a variance in the future. This was done in error, and we would like to clarify that the 100-foot residential properties and uses is not required. So just wanted to clear that up. Chairman Kramer, I am sorry, would you repeat that area of the summary report again, page 12? Ms. Gerhardt, it is on page 12 of 14, and it is right under the additional zoning ordinance regulations for distance requirement. Chairman Kramer, got it. Mr. Huff, should we delete that whole section basically? Ms. Gerhardt, yes, that is not relevant. We did additional research and it was done in error. Mr. Blitz, just to clarify, it was part of the report which will be submitted, so it is not being deleted from the report. You are being instructed to ignore that portion unless you have a revised staff report that you want to submit. Ms. Gerhardt, no, I don't. I'm just asking that it not be considered. Mr. Blitz, that's fine. But that's verbatim from the hearing on May the 5th. As a result of some interaction that we had from the staff, with the staff, after getting the staff report just the weekend before that hearing on May 5th, we basically interacted with them and they did their review, and they basically withdrew their comments. And that's how we got to that point. I think that's relevant because there was no other evidence, discussion, deliberation on that issue. It seemed to have been accepted by the board, which we felt was the reason why we took the position that the error was clerical, because while the board seemed to accept it without question, it then showed up again in the written decision. So that is, that was the history. As far as where we stand at the moment, we agree wholeheartedly with, we agree wholeheartedly with the staff on May the 5th, and we agree again in their current report that 164-140 is not applicable. And it really is a matter of simple statutory construction. The anatomy of 160-140, which is where we get this alleged 100-foot setback, is not tied to any use. It's just sitting there on its own. It needs to be linked to various uses, special exceptions, whatever other item that it's being applied to in the code. In fact, the very language in 164-140 says that it applies to uses that are subject to compliance. So you have to search somewhere else in the code to find, to link that obligation. And it's not linked anywhere to service stations, which is the admitted use that's been approved in this case. It's just not there. That's what the staff felt on May 5th. That's again what the staff is saying in its updated report on this hearing. And that's basically what the code is telling us. We can't otherwise prove a negative. It's just not there. And we don't see it. And if it could be applied indiscriminately, then the question is, how can anybody plan around it? How could any use that comes in the city, how would one know that that 100-foot setback would apply to them? And the answer to that is it's got to be linked somewhere else. And in the reports that you've seen, it is linked in many other places, in many other ways where it would apply, just not to a service station, which is the use applicable in this case. It is also, I think, relevant that in section 164-149, which is the controlling section that you look at and apply criteria to approve a special exception for a service station, it has its own dimensional requirements. So it's not as though there are no requirements. There's a 20,000 square foot minimum size, 10% landscape screening, service appliances must be beyond 10 feet beyond the building line of the building, behind the building line of the building. Service storage and certain activities must be inside the building. So these are all things that are similar in nature to this 100-foot setback that applies to other uses, but they're to protect neighboring properties. Also, the dimensional requirements in section 164-45, which are just the generic business zone dimensional requirements, apply as well. And that would include the normal front and side yard setbacks, which this project does meet, and the 2.0 floor area ratio, which testimony indicates the project does meet. As far as, I do want to comment on two of the cases that Mr. Blitz mentioned in his memo, because they are service station cases. And I took a look at the board's decisions. And I think we all assume, based on Mr. Blitz's email of July 3rd, that previous cases are not binding precedent in this special exception case, going on that assumption. That the Sheets case and the 7-Eleven case, in sort of one-line conclusions, do seem to indicate that the 100-foot setback was met, and the board may have felt, and the staff may have felt that it was applicable. but the issue really wasn't litigated. If you read reports, and I didn't sit through the hearings, obviously, but when you read the reports, there was no analysis as to why it did apply or did not apply. There was no apparent controversy, no real legal ruling on that. It surely looks like the setback was met, so the parties really had nothing to debate. It kind of got thrown in with the decision, but there's really no explanation as to why it applied. And I would contend that it did not apply in those cases, but I guess we could say, there was no harm there.
Mr. McGuire, what were the case references for those two?
Looks like the 7-Eleven was 19-03 and the Sheets was 16-02.
Okay, thank you.
And just to sum up, we would request that the board amend its ruling in this case to of course, correct the three clerical errors that seem to be admitted, and also to remove sections 40 and 41. And also there's a reference in section 21 to the applicability of 164, 140. We believe it does not apply. We agree with the staff. We think the staff's rationale is right on. And so we would ask that those basically 4 missteps in the board's ruling be corrected, and that we get quickly as possible to a final decision and get the appeal period running, because simultaneously with this case, we have a site plan in the process. So the clients expect spending funds, and with the expectation that this can go forward. Thank you so much for your time.
Board members have any questions for Mr. McGuire?
I don't know that it's for Mr. McGuire, but maybe Andrew or Eric, and I apologize if you said this in here. That was a lot of information, but thank you. Is there requirements for service stations as far as feet? I didn't hear you say that. I heard you say about the size of the building and the landscaping, but what are the service station requirements for distance? Does it exist?
Well, there are several dimensional requirements. There's a minimum of 20,000 square foot land size of lot.
Right.
There's a 10% size of lot landscape screening requirement. There's service appliances must be kept 10 feet behind the building line. And certain activities, storage must be conducted inside the building. And then the setbacks, and I don't have them in front of me, but the front and side yard setbacks are the general setbacks that are in section 164.45, which is the business district section of the code. So the standard setbacks apply. In addition to that, the 2.0 floor area ratio, basically building to lot size, also applies.
Any other questions?
Business setbacks are different from the 100 feet that were.
Yes.
Is on
You know, Josh, do you happen to know those offhand?
Yep, sorry, I was muted. Yeah, the front setback is required of 30 feet. We've provided 35. On the sides, the requirements are 10 feet. We have 52 and 26 feet. And the rear setback is 15, and we are providing 61. So we meet
Thank
all
you.
the bulk regulations.
Just as a matter of procedure here, do we need to re-swear Josh for that?
You can, or you can remind him that he's already been sworn, because this is a continuation of a case.
Yeah, okay. Then I will remind you, Josh. Okay. That's fine.
Thank you.
Thank you. Any other questions from the board? Um,
None for me.
Or staff.
Andrew or Mark, this is your upgraded staff report. Do you want to comment to it?
Thank you.
Hello?
I'm sorry, I was having issues getting logged in. I don't have much to say other than I agree with Mr. McGuire's statements. Also, the concerning factor, again, as stated, that this was brought to the attention of the Board of Zoning Appeals at the meeting. There was no discussion about this. Nothing was brought up by the board itself as to whether this applied at the public hearing itself. Then outside the public hearing, it ended up in the decision. So that's just a concerning factor of staffs. But outside of that, again, we concur with Mr. McGuire. It's not applicable. This was an actual determination by a zoning administrator. It was not an opinion that this did not, this section was not required. And we did look at, and then we would further question if the board felt this did apply, the approval that the board gave to this case. With the setbacks that were required, we found that I think there's a 500 to 600 square feet of area that can actually be in use. Once you apply the 100-foot setbacks on the rear and side of this property, because of the property that it creates the 100-foot setback as a panhandle. So it affects two sides of this property. Then you add the 30-foot front yard setback. So again, it would not be developable. But outside of that, again, that is not an issue because, again, staff believes that this section does not apply. And we're just available for any questions.
I guess we do have to, however, accept the updated staff report as a, for the record, as an exhibit. Is that correct?
You already did. You already did as Exhibit 17.
Okay, all right. I have a question then to that updated staff report under the analysis and comments section. Just for my own learning and enhancement here, I think there was a misstatement in the second paragraph, which reads, pursuant to zoning ordinance section 164-42.s, service stations is a special exception use in a B business zone zoning district subject to the provisions of zoning ordinance section 164-153. Did you mean to say 149 there? Or am I confused?
Give me a minute. Let me just double check the zoning ordinance.
Okay. And I'll tell you the reason I'm asking that question. There's the next paragraph down, which basically says in part that 164-149 applicable to the subject property located in the B business zone explicitly states that a service station is only subject to zoning ordinance section 164-149. Does not explicitly state that a service station is subject to 164-140. I just want to be very clear. We're all very clear on that, even though I think Mr. McGuire, explained it well. And I got one other question after that.
And I do agree with you. I'm sorry for the mistake. It should state 164-149. That is for automobile service stations. I believe 153 was for multifamily.
Yes, exactly. And that's why it just kind of bounced out at me when I went back and relooked.
Good catch. Thank you. I apologize for that.
No problem. And then the next paragraph, the zoning ordinance does, however, list specific uses that explicitly state the use is subject to section 164-140 as provided in attachment 5. I could not find attachment 5 anywhere. But I guess the question I'm going to ask is, was anything in that list make any mention therefore of service station, which is really what's being said here.
None of the uses that are subject to this section, or a service station is not listed as any use subject to the service station in any zoning district.
Okay,
So, so it's wherever automobile service station is mentioned, it does not subject it to this section of the ordinance, to the 140 section.
okay. I guess my final comment would be, and maybe this needs to be revisited at another time, but in looking at the code in general, the ordinances that, 164-140 needs to be looked at again and maybe clarified some. But is there anything else to be offered at this point?
Nothing from the applicant, Mr. Chairman.
Thank you. Staff,
Nothing, thank you.
comments or questions from the board?
I have none.
Just a reminder that we deferred the one
Right.
exhibit. That's it.
So coming back to that then, Mr. McGuire, you want to restate your objection? And then we can.
Well, I think up to this point, it's a pretty straightforward statutory interpretation that we're presenting. And although I think the information in Mr. Blitz's memorandum is useful to the board going forward for other purposes, as you say, maybe section 140 does need to be revisited. For purposes of this case, I think it just unnecessarily clutters the record with many, many pages of information that isn't necessary for your decision in this case.
Okay. So, Mr. Blitz, can you help me out here again in terms of what I'm now going to rule on in that regard?
So now you're just ruling on the admissibility
Right.
into the record. And the only thing that I would add is that in Mr. McGuire's argument, he made reference to issues brought up in that memorandum briefly. So normally when any of the parties or anybody testifying makes reference to a document, we like to have it in the record. But that's all I would add. It was a rather brief mention specifically about, I believe, 2 cases. I think that's what it was. He was describing in the memo that the sheets, I'm sorry, of course it's a spam. That he was making reference to the fact that in that memo, I described how the 2 cases that the board resolved with respect to service stations did find 164-140 applicable, and he was saying that those cases had passing references to the applicability, and the staff reports all in both of those cases did have. Well, no, I don't want to add stuff to Mr. McGuire's argument, but that's why you might want to consider adding it just because it was referenced by Mr. McGuire, but that's a somewhat minor thing.
For purposes of from what I've heard from the discussion, I would move that we do not admit the revised staff report as an exhibit to this rehearing. I don't think it's necessary.
Well, did I hear you say the revised staff report? Because the staff report is, I think, what Mr. Depot testified.
Well, are you talking about the exhibits to the staff report?
Well, I'm not sure. Exhibit 17 is the staff report, and that's already been introduced.
Okay. What are we
What
holding
I
in
thought-
abeyance?
Sorry, what I thought we were talking about was Mr. Blitz's memo that had all the
Okay.
various cases.
That's what I mean. Okay, that's what I mean. Nothing personal, Mr. Blitz, but I move that your report not be admitted to the record at this time.
Do we have a second?
I'll second that.
All in favor?
Aye.
Aye.
All opposed? Nay? So it's passed 2-1. If there's no other testimony, I will close testimony, or do you have a closing statement, Mr. McGuire?
No, nothing further, Mr. Chairman. Thank you.
All right, testimony is closed. Any further discussion by the board?
Yeah, I would just say, at the original hearing, I voted against the application. I felt that the applicant did not meet its burden of proof regarding the need for such facility. And I'll just, reiterate them for the record, or refer back to my comments in the previous hearing. Because of that, I feel it's probably, I'm just going to abstain to any formal motions in this hearing, in this rehearing.
Okay. Brenda, you have any comments?
No, I don't have any additional comments.
I guess from my perspective, I'm actually glad we've gone through this process. I think like most of these cases, or many of these cases, there's always something to be further looked at and understood. And I think it's helpful for all parties, even though this did tend to extend the length of this particular hearing. I hope not in any major way for the applicant. I would move that we go ahead and approve this application without reference to 164-140, so they can move ahead with the project. And do I have a second or further?
Yes, I second that.
Then all in favor? Aye.
Aye.
And opposed?
I abstain.
Okay, then we're past 2-1. This will close case number 20-02. Anything else I need to add, Eric, at this point?
No.
We thank everybody for your participation. Good luck with your project.
Thank you all.
Thank you.
Good night.
Good night.
Aye.
Thank you. Good night.
Mr. Chair, if I may,
Sure.
before we start case 2004, Andrea and I would just like to switch users so she can do a screen share.
Okay, that's fine. All right, I guess we can proceed. Case number 20-04. An application by Kathy Dubé, the applicant and property owner Olindo and Aurora Pagulayan, trustee, requesting approval of a special exception to operate a daycare facility for up to 8 children use, subject to the provisions of zoning ordinance section 164-90A, which references section 164-30G, to be located at 221 Alomar Court, Westminster, Maryland, pursuant to zoning ordinance Article 14, PD-9, Plan Development 9 Zone, Section 164-90A, Special Exceptions. In this case, we will proceed first with staff report.
Oh, yeah.
Thank you, Mr. Chair. If it is all right with you, I will provide a brief overview of the city staff report.
Okay, please.
The applicant is requesting special exception approval for a daycare facilities for up to 8 children use pursuant to zoning ordinance section 16490A, which references section 16430G at 221 Almeyer Court. The property is zoned Plan Development 9, PD 9 zone. Pursuant to the conditions for grant of special exception under section 164-170A of the city zoning ordinance, the information provided by the applicant did not address if their proposed use does not adversely affect the general plan for the physical development of the district as may be embodied in this chapter and in any master plan or portion thereof adopted by the commission. I would like to note that goal F2 of the 2009 City Comprehensive Plan is to encourage the provision of quality childcare services in locations that are convenient to Westminster residents and employees. The applicant did not address if their proposed use would adversely affect health and safety of residents or workers in the area. The applicant did not address if their proposed use would overburden existing public services, including water, sanitary sewer, public roads, storm drainage, and other public improvements. The applicant has applied for a water and sewer allocation for the proposed increase of 2 children. If the board were to approve this special exception application, there are approximately 1,114 gallons per day of water available for commercial uses. 30 gallons per day would be required for the additional 2 children. The applicant should provide testimony regarding pickup and drop-off times to determine impact on public roadways. And lastly, if their proposed use would be detrimental to the use or development of adjacent properties or the general neighborhood, or change the character of the general neighborhood in which the use is proposed, considering the services required at the time of the application, the population, density, character, and number of similar uses. The applicant should provide testimony addressing these provisions of the ordinance. Regarding parking, there are currently 58 single-family attached dwelling units located on Almeyer Court, requiring 174 parking spaces. There are currently 155 parking spaces located on Almeyer Court. A deficiency of 19 parking spaces is currently present and may not allow sufficient parking for the applicant's proposal. I've included an aerial map for more information. The applicant should provide testimony on current parking conditions in the Carroll Meadows area. And lastly, the recommendation, zoning administration recommends that the Board of Zoning Appeals deny the proposed special exception use due to insufficient parking. However, if the board decides to approve the proposed special exception use, staff suggests the following condition: that all proper licensing will be obtained by the applicant. Thank you, Mr. Chair. If it pleases the board, I would like to submit the application into the record as exhibit number 1 and the city staff report into the record as exhibit number 2. The applicant is here as well, Mr. Chair. If you have, and if anybody on the board has any, if you or anybody on the board has any questions, please let me know. Thank you.
Okay, both documents are accepted as identified.
Mr. Chair, I have a question that goes to the issue of notice.
Oh, okay, I'm sorry.
It's raised by the staff report, and so it's directed to the staff who ultimately give the notices. It appears that the applicant is seeking to have off-street parking in a common area parking lot that is not part of her titled property. And so my question is, was notice given to the party that controls or otherwise owns the common areas so that they could weigh in on whether she should be allowed to use that area for off-street parking?
Mr. Blitz, I believe so. Let me just confirm that for you.
Okay, thank you.
The common area is owned by Carroll Meadows Homeowners Association Incorporated with an account identifier of 07091-958. It has a PO box of 1554 Westminster, Maryland 21158. Let me look in the record. Notice was given to Carroll Meadows Homeowners Association Incorporated, PO Box 1554, Westminster, Maryland 21158, the certified notice.
So this brings up a point, Drew, that typically I've assumed that notices are going to the people that are listed in the application, and you've quite rightly given notice to someone else not listed in that list because they were a part of it. I think in the future, we may benefit by having the staff report have a page that says who all the notices went out to.
And with that, Mr. Blitz, I can talk that over with the zoning administrator.
Because otherwise we don't really have in the record what is, who was given notice. It's been presumed, at least by me, that the notices were going to those people listed in the application, and the application check, your process of taking in the application was making sure that that application listed all the requisite properties. But if you're also giving notice to other people, we need the record to reflect that.
And Mr. Blitz, the reason why that notice was given to them is because the application did not have that, and that was an adjacent property. So that was, the staff reviewed that, saw that, and sent that notice to the adjacent property.
Yeah, I'm absolutely glad you did. You did the exact right thing. It's just that I'm thinking, okay, if I hadn't raised this, we would have never had that in the record. And so I think if it might be useful for staff reports as an addendum or whatever to list all of the people you actually send notices to instead of just those that are listed in the applications. I don't know how often that occurs, that there's other people that you give notice to. But my concern for the board is just making sure that the record is clear who has been given notice, so that if someone later appeals saying I wasn't given notice and I should have, we have in the record that they were or were not given notice.
And Mr. Blitz, if I may, and I'll talk that over with the zoning administrator, but just for the record, in the file, I don't know if you can see this on my screen. Carroll Meadows Homeowners Association did get a mailing, and the back of that was what was on the back of the envelope for the green card to be returned. It has not been returned yet. I'm assuming it's somewhere in the postal service, but that was sent to them. But I will talk with the zoning administrator about that.
Thank you.
Okay. Any questions for, excuse me, any questions for Andrew from the board?
Just one quick question, Andrew. Were there any responses to the notice sent out by adjoining property owners?
No, Mr. Barrett. I also looked at my email right before we all came online today, and I did not have anything in my email.
Okay. I have no questions at the moment. At this point, we will turn this over to you, Ms. Dubé, and if you have any witnesses, I would like to swear both of you at the same time.
Okay.
So raise your hand, please, so I can see it, if you will. Do you swear to or affirm under the penalties of perjury that the testimony you're about to give is the truth?
Yes.
Thank you. You then can go ahead and make your presentation.
State your full name and address for the record, please.
My name is Michelle Jefferson, 416 Sycamore Avenue, Westminster, Maryland, 21157. I am a friend of Ms. Dubé's, or Dubai's, excuse me, and I am a building permit expediter by trade. And I got involved by helping Kathy because the process was very difficult for her to navigate. So I did try to help. And from what I understand, based on the conversation that you have had here, is that parking seems to be the main issue. And there have been times where I have dropped my grandchildren off here and picked them up. And I can tell you that there is no problem with the parking because the pickups and drop-offs are staggered enough to where Ms. Dubé has two spaces that are dedicated to her in front. She only has one car. There's only her that lives in the house. So that space is the one that is most of the time used with the pickups and the drop-offs. If there is more than one parent picking up and dropping off at the time, there are always very many other spaces around because the vast majority of the people that are here are at work at those times. And her hours of operation are 6:45 to 5 p.m. So, and as my apologies for the not answering or demonstrating, we thought we had answered most of the questions and whatnot that were asked. And we felt that since this was an existing daycare and we were only asking for an increase in 2 children, that we really didn't think that there was going to be any kind of detriment to the community, to the roads, or I understand the increase of the water. But as far as any kind of detriment to the neighborhood or the development of the neighborhood, I don't see that. And we apologize for not trying to demonstrate that with anything that we had put in prior to this.
So I have a quick question on the front side of this. So with operating hours being 6:45 to 5, are you providing Ms. Dubai a curbside reception of children, or are parents dropping off or whomever's dropping off actually parking temporarily to walk their children in? How is that working?
I mean, they're doing both. Some are some are walking up to the door, some are parking behind other car. Yeah. I'm already licensed for 6, so I'm requesting to be licensed for 8.
Has parking ever been an issue before? Has it ever been raised by any neighbors? Has it ever been raised by the HOA?
No, it has not. Most of the parents, when they're dropping off or picking up, the other people in development are usually at work. And they don't all pick up at 5. Some pick up at 3:30, some pick up at 4:15.
That was my next
All
question.
staggered throughout the day.
Kind of staggered, right?
Yeah. Yep.
What's the greatest number of vehicles that you might find in front of your residence at any one time?
2.
Okay. All right. Does the board have any questions of Ms. Jefferson?
Are they going to do a presentation on the special exception standards?
That's what I was going to get to next.
I'm sorry. I was just,
No.
I actually have, from the picture that's up, I do have one question. It looks like you can come in and you can go to the right or left, and it looks like there's which side of this is?
Okay, where it says 15 spaces, that's where Miss Dubé's house is.
On the right-hand side, okay.
There where your
So
mouth.
it does,
Yeah, right there. And then if you were to go over to, if you're looking at the pic to the left where it says 30 spaces, there are some that are vertical and then there are other ones that are perpendicular. And there are 30 spaces there. But like I said, anytime I've ever been here, I've always pulled right next to Kathy's car.
Are these spaces specifically marked for each residence? And are those spaces marked 30 for guests? Are they marked in any way for open parking or whatever?
They had been at one point, but it's not been kept up on. You have some of the spaces that have the numbers of the house that correspond with the numbers of the houses that are here, but that's not consistent through the entire parking lot.
Are there any,
Go ahead,
Sorry.
Larry. I'm sorry.
just a quick question here. Is there any difference in the drop-off and pickup procedures during this, pandemic, just in terms of length of stay of the cars, et cetera?
Well, she has her protocols in place for prior to walking through and whenever they leave, wearing masks and the hand sanitizer. Most of the parents, when they're coming to drop off, they're running late to get to work. And when they're coming to pick their kids up, they're most likely hurrying up because they have to hurry up and get home. Their time here is 5 minutes or less, and 5 minutes is long. But it's most of the time because maybe a shoe came off or we have to put the shoe on before we walk back out.
Thank you.
In as much as you seized on the parking situation right away, you heard from Mr. Gray on behalf of the city staff that other conditions, they did not feel you had addressed them adequately. So we need to question those and kind of walk through each one.
I do have somewhat of a statement if you would like, if it could be read into the record.
Okay, if you want to make that as part of your opening statement, then that's fine. And then we'll get to the questions that for each of these areas that the staff did not feel were properly addressed.
That's what we were hoping to do, was to address those particular concerns.
Okay, very good. Go ahead. Thank you.
The increase of the 2 children in the existing daycare, we feel will not adversely affect the general plan for the physical development of this district. Having 2 more children floating through and this area, I don't see where any kind of adverse effect that it would have. The existing daycare is very convenient to the existing clients that she has, in addition to any other new clients that she could pick up. She does have a waiting list of 2 children that would love to be able to take these 2 additional spaces. And she has 2 of her parents that are teachers in the school system right here. So she is very convenient. I don't see where the health and safety of anyone in the neighborhood is going to be adversely affected with 2 additional children. And with, I wasn't sure exactly how to calculate the additional gallons of water that would be for.
Can I interrupt you there for a second before you move on to that point?
Yes, Mr. Chairman.
I want to come back to the general question I asked earlier in terms of others in the neighborhood, or neighbors and or in the neighborhood, ever having expressed any concern for having a home daycare there in the area and having caused any concerns for people. I just want to make sure that that's covered as completely as you can about.
And I understand.
In the past. I mean, she's been in business for a long time.
Yeah, that's what I was going to say, 1996. And to our knowledge, there has not been any record or concern from any of the neighbors that for the daycare here. It's not like she lets the kids run around screaming and yelling or anything like that. She's very good about making sure that they're under control.
Well, yes, I understand that. I just wanted to ask the question because there's a nice big backyard and it looks like it's pretty well appointed to accommodate the activities of the ages of children that she has. But I just have to ask the question.
3 of my grandchildren, or excuse me, 2 of my grandchildren come here now, and a third would like to come here. So Kathy's the bomb. She does a good job here. She truly does. And she comes very highly recommended across the board.
Okay. Thank you.
Should I continue with what I was saying before?
Yes, please. Yes.
Oh, I'm so sorry. Okay. As far as the additional gallons per kid, you had said that, Andrew, that it would be 30 a day. And based on your comments of 1,100 gallons being available, I don't see where we're going to overtax the system on that. Oh, and as far as if 2 additional children aren't going to change the neighborhood, they don't go into anyone else's yard, and the one conservation area, I'm not even sure if you know where that is. They don't travel outside where the yard is. And we already did talk about the parking. As far as the signage is concerned, I'm not really sure what the question was or the implication was about signage in the front yard. She doesn't advertise in that manner, so I don't see where any signage would be an issue. I mean, she puts Halloween and, holiday decorations up, but nothing that is pertinent to the daycare.
But from a home-based business, not a center.
Right.
And I hope that takes care of the things that we apparently did not demonstrate in the beginning. And I really thought it was that we hit all the bases. And from doing this I don't normally do zoning hearings and variances for a living, but I apologize for missing all of those demonstrations. Or not.
Today's hearing is when you were to do that.
Oh,
It's not like you were supposed to have already proved your case. Today is the day.
oh, okay. I'm thinking here, I really screwed up. Like, how did I miss all that? Okay, well, I feel a little better now. Thank you.
The staff was merely pointing out that your application itself and your pre-hearing statement, I think that's what, I don't want to speak for the staff, but I think I interpret it as they were saying you didn't address those points yet. And
Okay.
Therefore, they're directing you to do that at this hearing.
Okay, understood. Understood.
I want to come back to your application and the water and sewer allocation application that you submitted, and address Andrew. As far as the city's concerned, that's an appropriate allocation. I mean, application, I'm sorry.
Mr. Chair, when we if the board does approve this use, we will get we'll take further review of the application. Right now, we have water available in the commercial category.
Right.
There's 30 gallons that it would use. So once we get past the Board of Zoning Appeals hearing, that's when we'll take further action with the water and sewer allocation application.
Okay.
Excuse me, Mr. Chairman.
Yes, go ahead.
Also, we used Maryland Department of the Environment multipliers to determine how much water would be needed. So just to let you know how we came up with that figure.
Oh, good. Thanks, Andrea. I guess I have no other questions from me. Does the board have any other questions?
I have a question, and I apologize if I missed it. Am I accurate that you're licensed for 6, you have not officially been approved for 8 yet with a new license? Is that correct?
They actually did approve me. I was just waiting on zoning.
Okay.
Well, I guess I do have one more question. Inasmuch as the staff report also indicated if the board did approve, of course, then it would be with the condition that all proper licensing will be obtained by the applicant. Are you prepared to actually submit all those applications and in a timely manner?
She already has been approved for an increase from 6 to 8, and so she has applied for and received that approval.
I'd be cautious in this area. This board does not have the authority to intrude on the regulatory authority of the licensing scheme. So it just isn't a subject. She has to be under Maryland law licensed.
Yes,
We are.
absolutely.
The zoning
I did
impact
send
doesn't
a
matter.
copy of my license in. It should be there as an exhibit.
Right.
Yep.
In a zoning context, this board doesn't get to weigh in on whether that's valid or not, or whether it
Right.
meets the standards or any of that type
Right.
of thing.
Okay. Is there anything
My
else?
question,
I'm
my
sorry, go ahead.
questions have been answered, so I'm fine.
I have two questions of staff, if that, with the goal of helping the board on the parking question.
Okay, go
I
ahead.
don't know whether Andrew's still there. My first question is, do we have any historical record information that could be submitted into the record as to why, even under the residential scheme, not including home occupations, this development is short by 19 spaces?
Right now, Mr. Blitz, I do not have any documentation that I'm prepared to submit at this time to the Board of Zoning Appeals regarding the parking.
Because they were given authority by a letter that was attached to the application, and that's on Exhibit 1, in 1996 to operate a home daycare for 6. And implicitly, that would have included an evaluation of the parking spaces. And I just wonder whether the standard changed over time, or whether to go up from 2 to 3, or what would cause it to, I mean, right now, under the parking ordinance, she's not valid even as her current operation.
And Mr. Blitz and Mr. Chair, if I may,
Yep, go ahead.
I am not certain as to how that letter from back in the 1990s, it was evaluated. I can't speak to that.
I guess the question I have is it the staff's position that she's not a valid use now?
And if I may, Mr. Chair, may I just bring the zoning administrator in, Mr. Depot?
Sure.
Again, the video takes a while to warm up, I guess. I don't know. No, we did not evaluate it as to, we did not come to the conclusion that it's not invalid. If anything, it would be a legally non-conforming use because it was given a valid approval. Again, like Mr. Gray mentioned, I can't speak to how or why the approval was given or whether parking was looked at that moment or that time. It's not, and I don't believe the parking has changed. It is very typical that you have the 3 parking spaces per townhouse use. The concept being that you do pick up those additional parking for visitor parking. A single family house is required 2 to 2.5, but typically of driveways, garages, on-street parking. So in townhouse communities, you have the private roadways and you don't have that on-street parking. As you can imagine, cars park in front of the buildings. So they are given a higher parking requirement to pick up this visitor type of parking or potentially other use type of parking. So again, staff, only due to the actual ordinance itself and the parking regulations, have concern with this, not with the use itself. And we were looking for more information as far as parking and how it actually operates. We looked at the photos that were provided, and that was a concern that we had, that there were no labeled parking spaces. And maybe it was in the past, and that's good to hear. That would be certainly helpful. But in this case, we did not have that information. It wasn't clear what was guaranteed to the applicant, what was provided as visitor parking. So it made things very difficult for us to provide any really good review, whether there was acceptable parking, even though it didn't meet the parking requirements in this case, or if there was not.
Because they don't even meet the parking requirements for their residences.
I would say so. If you were looking at it today, I don't know if you look at the larger picture versus this just, if this was part of, if this is just one section of a larger development, and when you take all 4 sections together, just say if that was the case, all 4 combined might meet the parking space requirements for the entire development. But when you look at this one section only, it may not. So I don't know if that's the case, but that's not uncommon either. You would hope that they would try to meet all the parking in that one section versus dispersing it throughout the entire development. But I think we were looking at more of the function of the parking spaces and how they operated today. And then that's why I think the testimony provided by the applicant was certainly helpful.
I could take the computer outside right now and show you how empty the parking lot is.
In cases like this, we do look for some type of parking study would have been helpful, demonstrating that throughout the day or throughout these periods of time, there's a certain amount of parking spaces vacant versus used. That would have been a clear indication that there would be acceptable or available parking for the use. The staggering information was important, that we were not aware of how they were dropped off and how they were picked up. Again, but back to Mr. Blitz's comment, yes, for this section, this area, it would not, the entire development does not meet the parking requirements. Oh, I'm sorry, just in this section, in this portion.
Is that it, Eric?
Yes.
Okay. Does the applicant have, or Ms. Jefferson have any closing statement, or are you're good?
We appreciate you taking the opportunity and giving us the opportunity to put this forth. This wasn't an easy task. It's a little confusing, even for someone like me that's been in the business for a while. It's a little tough, and it's scary even to have to sit here with her to do this. And it wasn't as bad as what I thought it was going to be, but I am very concerned about the not being able to adequately put forth a full package. And I don't want you guys to deny her package or deny her request because I was inadequate in helping her through this process.
I think Mr. Blitz kind of put some of your angst at ease there, and we think we are fairly friendly and open and.
Oh, that's not it, but that's not what I meant by that. It's just
No,
the
I
whole
know.
process is, and some of the wording is tough, and it's just a little intimidating to try to make sure we get it the right way, because there's so much that's riding on this, and her having to be able to help 2 more families out because the daycares in the area, they're so full, or the other ones have closed down, and it's real tough to find decent daycare these days. It really is.
Especially under the current environment.
Yes, sir.
Okay, if you're complete, then the board have any other questions at this point? If not, we'll close testimony.
Can I ask,
Okay,
we didn't take in her pre-hearing report. Did she attach, let me look. I'm just making sure we got all her documents in. Were they all attached in the application, or did the pre-hearing include anything else?
When I did the when I did the last submission, I put a copy of everything that we put in along the way. We sort of did some piecemeals here and there. And then the last submission I made was a whole package of everything. It should have been anyhow.
Mr. Blitz, and Mr. Chair, if I may.
yeah, please. Andrew.
Mr. Blitz, I believe we did include the application and the pre-hearing statement in the city staff report sent to the board on Friday.
Okay, great, thanks. Just trying to make sure everything she
I
has.
think it's all there from my perspective. Okay, I guess we will close testimony. Time for board discussion, if any.
The only thing I will address the parking with what I'm seeing, even though it's one big development owned probably by the same folks, where she's actually lives in the home and the daycare, it looks like you have 32 homes and 95 spaces just in that section. So I think that that alleviates any parking issues that I would have based off of the location and where most of the spaces are.
Yeah, I would agree. And with the comings and goings of people at the hours that they are, and it being staggered further, I mean, that certainly stretches things out. I don't think there should be any particular issue, and none have been expressed so far. But
Yeah, I would just agree that, I mean, the testimony was very helpful in terms of any parking concerns I may have. And I also thank you. Actually, you gave, through your testimony today, gave us plenty of information for us to make our decision. So thanks so much.
Thank you.
So with that, do I have a motion?
I'll motion to approve taking the daycare from 6 to 8 children.
And second?
Second.
All in favor?
Aye.
Aye.
Unanimous, so approved. Thank you, and congratulations, Ms. Dubai and Ms. Jefferson.
Thank you.
Your
Thank
help.
you so much.
Good job.
Thanks. Okay, so what, Andrew, I'm assuming you'll tell me what's next in an email tomorrow?
Yes.
Okay, perfect. All right, guys, thank you very much. And it was nice to put faces to all the names.
Good. Nice to see you too.
Thank you.
Thank you. We are done.
Mr. Chair,
Oh, I'm sorry. Go ahead.
if I may, I just want to, as customarily do, if we have another case pending, just to let the board know of an upcoming case. As you know, Mr. Chair, from correspondence today,
Yep.
there is case number 2005, which is an application for a microbrewery and pub brewery use, which will be a distillery. If it is approved, licensed under the Annotated Code of Maryland Alcoholic Beverages Article to be located at 116 to 118 East Main Street. So that is being advertised, and that is proposed to be before this body for review in November. Thank you, Mr. Chair.
Quick question. Just a quick question. Where was, is case 20-03? How did I miss that?
2003 is a case that we have requested more information to, and we have not received it yet. So that
Okay.
still has a placeholder, but we have not received any more information regarding that case. But when we
Okay.
do,
That's fine.
it'll be in front of you all.
Thank you.
Larry loves these cases. All right, thank you very much, everyone. We are officially adjourned.
Sounds like I'll see you next month.